Multani legal passage number 2. Start. Learned counsel for the petitioners challenged both the impugned judgments on the ground. Firstly, that the petitioners herein were entitled to the transfer of the suit house in their favor on the basis of the agreement to sell, which had to be specifically enforced as being pertaining to immovable property, secondly, both the learned lower courts had wrongly assumed that the agreement to sell was without consideration, and thirdly, the respondent number 2 was not a bona fide purchaser, full stop. Paragraph. In so far as the first ground is concerned, originally the contention of respondent number 1 was that he had executed no agreement to sell in favor of the petitioners herein, although he admitted the factum of mortgage, full stop. But in his evidence he admitted his signatures on both the documents, namely, the mortgage deed and the agreement to sell, and pleaded that they were without consideration, full stop. However, in the sale deed in favor of respondent number 2, he had admitted the factum of mortgage in favor of the petitioners, full stop. He did not produce any evidence to show that he had not executed any agreement to sell in favor of the petitioners, or that the said agreement was executed under duress or misrepresentations, full stop. It is a registered document and its contents and execution have been proved according to law, full stop. The mere denial of execution have been proved according to law, full stop. The mere denial of execution and then admission of signatures thereon by the respondent number 1 clearly proves the execution of this document, full stop. The small thus be seen that the agreement to sell the house in question was actually executed by the respondent number 1 in favor of the petitioners, and it was also got registered, full stop. The existence of this document cannot, therefore, be denied, full stop. This agreement pertaining to the sale of immovable property had to be specifically enforced, full stop. Paragraph. So far as the second ground is concerned, it may be mentioned that the transfer price of the suit house was rupees 12,000 and it was mortgaged with the petitioners for rupees 15,000, full stop. It appears that the intention of the parties was that this mortgage amount shall be the sale price of the suit house, and that is why no other amount as sale price was mentioned in the agreement to sell full stop. The mere fact that the vendor agreed not to receive any additional amount as sell a fictitious, इसके स्पेलिंग लिख लें FICTITIOUS document or the transaction as without consideration full stop. Even otherwise, this was not the plea of the respondent number 1 in his pleadings full stop. By holding that the agreement to sell was without consideration, both the lower courts have travelled beyond the pleadings of the parties and have taken into consideration matters extraneous to the pleadings full stop. During the days when the suit house was intended to be sold to the petitioners, rupees 15,000 could be a reasonable price thereof, and the respondent number 1 willingly and voluntarily agreed to transfer the suit house in favor of the petitioners on that very price, which he had received in to ये इसके पहले TOTO as